Welcome to our video. My name is John Watts, and we're going to talk about a case called Bishop versus IC System. It's out of Florida. It's from a number of years ago, but I think the attitude and the approach of the debt collector will be very interesting to you. And this is a company that I'm familiar with. My law partner and I have sued them a number of times. We did a jury trial in federal court a number of years ago against this company. And what you'll see in this case is very typical of the way that debt collectors want to treat consumers, and the creative, maybe absurd arguments that they will make to try to protect themselves from having to pay the consequences of violating the law. So we have this family, and they live in North Carolina, and they get called by this debt collector saying, "You owe this dentist Richard Salvatore in New York." And they say, "Well, wait, we've never been to a dentist in New York. We don't know a dentist named Richard Salvatore. And when you say this work was done for our son, he was actually an infant who had no teeth." That's a pretty good explanation. But debt collector says, "Well, we're going to keep calling you." So they call about this other bill, and it's explained, look, there was an insurance problem, a billing problem, and that's all been fixed. Well, IC System sends a letter October 20th and November 24th. They're making phone calls. Jeff Bishop says, "Hey, stop calling us." And IC System says, "Well, we're going to continue to call unless you tell us to stop calling you in writing." So he writes a letter to IC Systems. And so this is kind of an interesting letter. "I'm returning your letters to recycle. Repeatedly pointed out we paid every penny we owe, and that's nothing. Co-payments were made. All other charges covered not by one but two health insurance companies. The doctor still won't bill it appropriately. We've explained it to them. Their continuing failure to perform such basic function of their job reflects a level of incompetence matched only by your own in attempting to collect another non-existent debt on behalf of a certain Richard Salvatore, a dentist none of us have ever seen in a state, none of us have ever resided, for dental services rendered to a then infant who didn't even have teeth. And in the highly unlikely event associates believe they have a non-frivolous claim, they can contact us directly. If you write to us, we're going to discard it." Okay. So they get another letter, and then they get calls. And here are the calls coming in. It's a fairly typical pattern from this debt collector where they will continue and continue to call. And on January 9th, the husband says, "Well, hey, look, did you get my letter?" I said, "Oh, yeah, we got it. But we're going to continue to call you until you provide proof." Now, let me stop here. This is something that a lot of debt collectors will do. They'll say, "Look, we say you owe the debt." And then you reply back and say, "Well, I don't owe the debt." And the debt collector says, "Okay, you have to prove to me that you do not owe the debt." In other words, the debt collectors take the position, and I've had them say this to my client before, you are guilty until you prove that you're innocent. Now, you kind of take a second and think about that, and you go, "Well, wait a minute, I thought we're in America. I thought you're innocent until proven guilty." And what debt collectors, what they view this as, is they say, no. If we say you owe the debt, then obviously you do. You have to prove beyond any doubt for us, the debt collector, that you really don't owe the debt. And until you do that, we're going to keep blowing up your phone. We'll do all this stuff to you. So kind of naturally, these consumers sue them. I mean, you tell them you don't owe the debt. You write them and say, "Don't call me anymore. Don't contact me anymore." And now the debt collector continues to call, and they say, "We're going to keep calling until you prove." So you sue them. This is the best way in most circumstances to get a debt collector to stop breaking the law. Now, it's funny, when we sue these guys, they go, "Oh, well, if you had just told me I was breaking the law, I would have stopped. Or if you had just had your lawyer contact us and explain to us that we're breaking the law, then we would have stopped. The funny thing about that is these debt collectors have lots of lawyers. They have lawyers that represent them. They have lawyers that work for them, outside lawyers. And it's funny because they take the position, well, you as the consumer have to go hire a lawyer. That lawyer has to explain to us we break the law, and then we'll stop. Because all of our lawyers that we have, all of our compliance department, all of that is not sufficient for us to follow the law. Instead, you, the consumer, have to police us and beg us to stop breaking the law before you sue us, because it's just unfair to sue us. It's just an absurd position. But anyway, let's get back to the case here. So the allegation is that the Fair Debt Collection Practices Act was violated here. And there's a number of sections that were violated. We're going to focus here on the 1692C and then little c. And that's basically saying, hey, I told you in writing that we're not going to pay it, or that we want you to stop communication, and you continued to contact us. So we want statutory damages of $1,000, actual damages, damages for emotional and mental anguish, and attorney's fees. And so the bishops, the consumers, move for summary judgment. Summary judgment is saying there's no reason to have a trial. It's so obvious that we would win on this issue. And so we have this, what's called the standard of review. This is just what the law is. So here we go. Let's talk about the 1692C. And here's the text of it. Consumer notifies the debt collector in writing. Consumer refuses to pay the debt, or, it's not and, you don't have to do both, it's just or. The consumer wishes debt collector to cease further communication, then the debt collector shall not communicate. Well, the parties agreed that the plaintiffs are consumers, and then they agree that this is a debt, and then they agree IC is a debt collector. Now, this is very common. They'll deny in their answer they're a debt collector, but then once you actually go to the effort to prove that, then they'll say, oh, well, yeah, of course we're a debt collector. And they don't dispute that there was this letter that was written. And they don't dispute IC received it, and that they continued to call. And so the whole battle here is, let me get down to this, the sufficiency of the letter. And so IC system argument focused on one issue. It argues the letter did not satisfy the requirement. And because you did not ask IC Systems to stop contacting your family, it was free to keep communicating. And so this is very instructive of how the debt collectors work and the attorneys that represent them work. Rests on the fact that letter did not include the actual words of the statute and did not literally say cease further communication. And I like how the judge put it. He said, yeah, he didn't use those exact words, but his words expressed the same message, just with more bite. Okay? And so then we come up here. It's saying, look, the doctor can contact me. Well, that's obviously saying you, IC, are not to contact me. And I'm going to throw away your letters or return them unopened. That's pretty clear. Don't want to receive any more mail. And then the fact that the letter does not literally ask to cease communication does not deprive the letter of its plain meaning. And here's a famous quote, there's no surer way to misread any document than to read it literally. And so the context makes it clear they did not want to be bothered. And this is kind of interesting. In addition, the sarcastic and insulting tone of the letter makes the request more clear, not less clear, as IC contends. And so then we go on, and in this case, no reasonable disagreement exists about the inferences. While lawyers may parse the meaning of words into bits, no reasonable juror could stumble or would stumble over what Bishop communicated. Context and common sense make the message clear. Bishop wanted IC system leave him and his wife alone. And so they also, this is interesting that IC does not address whether or not the letter notified it. They refuse to pay the bill. And this is an important point. We often talk about a cease communication or cease and desist letter. And that's true. But if you say, I refuse to pay this debt, that's the same thing. And a lot of times collectors will ignore that, even though it plainly states that in the law. And then when you sue them, the collector will say, well, no, you have to say literally cease and desist. And instead all you told me was you weren't going to pay this. Let's see, 1692C can be triggered if a consumer notifies debt collector either that they refuse to pay the debt or that they wish the debt collector cease to communicate. It's not both. Clearly refuse to pay the bill. Okay? And so then the court is just making this clear that that is sufficient. And then there's some language about, what's exactly is the standard. But then down here we have some important language. Statutes not require a consumer to use any specific language or magic words. Okay? That's not what this is about. And so then the court says, well, look, I'm going to let the jury make a ruling on the damages here. So take-home lesson from this case, this Bishop case, and I'll get to the top of this document here so you can see the full name of it. This decided May 12, 2010, Middle District of Florida, Tampa Division. So the take-home lesson from this is that if you tell a collector in writing, I refuse to pay, or you tell the collector, look, stop contacting me, and you don't maybe use all the, quote, magic words that these debt collectors want to talk about, it doesn't matter. If the meaning is clear, then they have to stop calling you. Now, my suggestion is if you want them to stop calling you, make it very clear. Just say, I'm not going to pay this debt, and I don't want you to ever contact me again. But you can see how these debt collectors will get a letter that says, basically, debt collector, you're incredibly incompetent. Your client is incompetent. Don't bother me again. I'm not going to open your letters. All that type of stuff. How a debt collector go, well, it seems like he wants me to keep calling him. So that's what you're dealing with when you deal with these collectors. And when they take these positions, the way to get them to stop taking these positions is you sue them in federal court. And then you have a judge explain to them, well, this is what the law actually means, and it means what it says. So I hope that this has been helpful to you. If you live in Alabama and you have a question, whether it's about IC Systems or another collection agency that's contacting you, or whether you should or should not do one of these cease communication or refusal to pay letters, or maybe you're just curious, how do you talk to these guys when they call you? Feel free to give us a call, 205-879-2447, or you can contact us through our main consumer website, alabamaconsumer.com. Thanks a lot, and appreciate you spending time with us. Bye-bye.